you are seeing this video the first time you are seeing me, this video is under a playlist. I don't know if you are seeing this video first. You are not doing that. You should. This video is inside the playlist. Look for the playlist. It's Lego method for year 1 students. Start from the beginning, so you cannot just jump to fact finding and dispute resolution when you've not watched what is Lego method. Do you understand what I'm saying? So, all right, ladies and gentlemen, this is Professor. So today we'll be looking at fact finding and dispute resolution. But before we get into that, you should know that there is a very big difference. Okay, this is how we'll start. There's a very big difference between dispute resolution, resolving dispute, and ending dispute. Some of you will be asking, are they not the same? Now, let me give you an example. Let us say you are a parent and the two of your children are fighting. This toy belongs to me. This toy belongs to me. No, your own toy, you throw it away. This one belongs to me. These are identical toys you bought. One person has thrown his or her own toy away, and the other person is claiming that this one is his toy. So two of them are claiming that that it is the other person that threw his toy away, and they are talking about that particular toy that is remaining. That this one is saying is his own. This one is saying is their own. If you are to resolve the dispute, you are to ascertain who owns the toy. But that is resolving dispute. Now, ending the dispute is now when you go and you collect the toy and say, well, two of you should go and sleep. Go and have your siesta. You have ended the dispute, but you've not resolved the dispute. Do you understand? So, resolving dispute is actually getting to see to the just conclusion of the matter. Now, before our laws, before our body of laws, before our practice as we know it in resolving disputes, before now, I mean in the old traditional society, in our primitive society, we had ways we resolved disputes. And those ways, if I can be honest, are actually very effective. Because we had what we call juju. Juju, when you swear, let's say for example, you are dragging a land that is not yours. Okay, let me still use those toys. Your two children are dragging this toy. And you now bring juju for them and say, swear. Anybody that swears and is not the person that owns that particular toy, the person will not wake up the next morning. One of two things will happen. It's either the person that knows that this is not his own will not swear. Then by that way, you have now known the real owner of that toy. Or that person that intentionally, he knows that this particular toy does not belong to him. He will go ahead to swear, and the next morning he will not wake up. So either ways, you have found the real owner of the toy. And that was what was used at the time. You are dragging a land with somebody, they will tell you to swear. It's called trial by ordeal. Trial by ordeal. So that when you swear or when you go through this trial by ordeal, this is how you define the fact. No need to come and be calling witnesses. Swear. If they want you, will swear. Do you understand? So that was the way we were doing things before. However, when the British people came, they had to amend most of our practice. They now set up a sort of a standard that must be reached. Now, if you are resolving dispute, the kind of dispute resolution mechanism we have now, these are sets of standards that once those standards are followed and the both parties see that these standards were followed to the last without bias, then everybody will accept the outcome of the dispute resolution mechanism. What do I mean? Obi and Ada, they are quarreling over a land. And they go to court, just like we know it. And they see that everything that was done in court was done with dexterity. It was done with high standards. Everybody knew that justice was done. How the facts were being found, how the witnesses were being examined and cross-examined, how the judge gave his judgment. Everybody, once they see that these standards were met, once they see that these objective standards were met, they will have no other choice than to accept the judgment. The only time that most of the times they don't really accept the judgment is when they will now look at it and say, there are some elements of bias that this judge has shown. This judge did not allow for this particular witness to be examined in a certain way or cross-examined in a certain way, and therefore it affects fair hearing. So most of these things, we usually have problems with hearing, with courts, with judgment, because either of the party thinks that the judge did not follow the prescribed objective standards. And so these standards were like the litmus test. These standards were the watchtower of what you expect in order to say that, okay, justice has been done. But before we go into all those things, we have to know that we have, in resolving disputes, we have the adjudicatory method and we have the non-adjudicatory method. However, these standards that I was talking about is applicable to all the methods I've just mentioned, the two methods I've mentioned. And so when you're talking about the non-adjudicatory method, you're talking about things like conciliation. You're talking about things like arbitration. You're talking about things like mediation, negotiation. Of course, mediation is when somebody is in between, mediating between you and this person. So you people are not in court. You people are not filing any matter in court. You people are not hostile with each other. But you people want to resolve this dispute. You look for somebody that will reconcile the two of you, mediate between the two of you based on what the problem is. Conciliation also the same thing. Mediation and conciliation usually goes hand in hand. In negotiation, you don't need somebody between the two of you. You can talk to that person yourself. You negotiate the terms that you want. Now, arbitration, it's kind of looking like court, but it is not court. Because in an arbitration, you have somebody that is sitting as an impartial arbiter. And so after listening to both parties, the arbiter would have to give a judgment known as the arbitral award. And that arbitral award is binding on both parties. Of course, even the negotiation and the conciliation and the mediation, whatever it is, or whatever agreements that you people have reached based on the dispute resolution, is really not binding until it is now adopted in court, and the court will now give it as a consent judgment. Now, if you want to go into a kind of adjudicatory method or a kind of dispute resolution method that would be binding from the onset, you better go with the adjudicatory method. And what is the adjudicatory method? Adjudicatory method is simply litigation, going to court. That one is any judgment that is given is binding. The judge sits, you open your case, the other person cross-examines your witnesses, you do the same to the other person, the judge will listen to your final addresses and will give judgment. Of course, under the adjudicatory method, we have types, we have classes of, or methods under the adjudicatory method. Now, of course, we know that, as we have explained, adjudicatory method is what? Is courts, is litigation. Why non-adjudicatory method is any other method of dispute resolution that is not our court system. Just like we mentioned, the negotiation, the conciliation, the arbitration, the other shons. So in the court system, or in the adjudicatory method, or in the litigation method. So adjudicatory method, you can call it litigation when you go to court. Now inside that particular adjudicatory method, we now have two types or two ways where a particular country can practice, or where a particular court can want to practice its own adjudicatory method. Number one is the adversarial method, or adversarial. Is it adversarial or adversarial? I will put it on the screen. Number two is the inquisitorial. Now, what is the adversarial? Permit me to call it adversarial, even if it is probably not going to be adversarial. So I'm trying to see, is it adversarial or adversarial? So just permit me. But you know what I'm saying because you're seeing it on your screen. Now, adversarial or adversarial system is when the judge does not even come down to the arena of conflict. The judge is just there. you are the ones that will present the facts to the judge. The other person will present his own facts to the judge. The judge is not going to be asking a lot of questions. The judge is just there taking what you are giving him. You bring, he will take. You bring, he will take. And when he now takes all these facts, what are facts? Facts are stories of what happened. Facts are things that, of course, when you are talking about facts, you are talking about it with evidence. Because when your fact is now in conflict with the other person's fact, you people are adverse. Do you understand it? You people are adverse parties. Because what you are saying, Obi slapped me. This one says Obi did not slap him. It is word and opposite. So which one are we going to take? So you are fighting with this person. You want the judge to come to your own side. That is adversarial method. You want the judge to come to your own side. So you are fighting with this person to get the judge's mind, or to get the judge's side, or to get the judge on your side. So when you are fighting with this person, you are bringing evidence in order to prove that those facts exist. So when your fact is clashing with this person's facts, they are, what do we call them? That is facts in issue. Facts in issue. And you must have to present evidence to prove your own fact in the fact in issue. So when you present evidence and the other person does not present evidence, which one will the court take? The one that presented evidence. So the judge is just there in the adversarial method, looking at you people, smiling, enjoying the AC, writing, giving you people are bringing facts. Now what will the judge do? When you people are done bringing facts, the judge will now apply the law to the facts. Especially when the facts have been proved by any of you, we now apply the law and now reach a particular resolution, which is binding on the parties. That's for adversarial. Now, for inquisitorial method, the judge is not just going to be there looking at you people will bring in the facts. No, the judge will come down and tell you people to give me, will be asking for the facts himself. So in adversarial method, the judge is just there in the parlor. It's just like somebody in the parlor waiting for food to come. The food being your facts to come to him. But in inquisitorial method, it is just like the judge, or it's just like somebody in his parlor going to the kitchen to carry the food. So the judge is asking questions. Go do it. Oh, what happened? Okay, what did you do? Okay, you now, why did you do it? What did you do? You know, talking, even the judge is examining, cross-examining, doing everything. But in adversarial method, the judge is not asking questions. The questions are meant to be asked by the opposing party when the opposing party cross-examines. But in inquisitorial method, from the word the judge is inquisitive. He wants to know what is happening. He is inquiring and he's getting the facts himself. You see it in all these TV shows, judges, Judge Judy and all that. Yes, that's inquisitorial method. But in adversarial method, the judge is just there. All the shenanigans, all the fights that are fighting, all the debates, all the cross-examination, he's just getting the facts from you people. He's not stressing himself. So I have not seen the difference between adversarial and inquisitorial method, which are under the adjudicatory method, which is a method of dispute resolution. The other one being the non-adjudicatory method. Now, what are the examples of non-adjudicatory method? You have forgotten. The conciliation, the mediation, arbitration, negotiation, etc. Anyway, so when next I come your way, we will not look at anything because we are done. Adjudicatory method, fact finding and dispute resolution is the last topic in legal method. So if you have reached here, congratulations. Are we really done? Oh no, I've not done legal research. Sorry, I've not done legal research, and that should be the last one. So if you are seeing this video the first time you are seeing me, this video is under a playlist. I don't know if you are seeing this video first. You are not doing that. You should. This video is inside the playlist. Look for the playlist. It's legal method for year one students. Start from the beginning, so you cannot just jump to fact finding and dispute resolution when you've not watched what is legal method. Do you understand what I'm saying? So, peace.